Did you know that some people facing deportation may still have a legal option to remain in the United States? Many people believe that once removal proceedings begin, there is nothing else they can do. But depending on the circumstances, U.S. immigration law provides certain forms of relief that may allow someone to remain in the country legally. One of those forms of relief is called 42B, officially known as cancellation of removal for certain non-permanent residents. However, this benefit is not available to everyone, and qualifying for it can be challenging. In this video, we'll explain what 42B is, who may qualify, the main legal requirements, and why every immigration case is different. 42B is an immigration benefit available to certain individuals who are currently in removal proceedings before an immigration judge. If the judge determines that all legal requirements have been met, they may cancel the person's removal order and grant lawful permanent resident status, commonly known as a green card. It is important to understand that this benefit is not something anyone can apply for at any time. It is generally requested while a person is defending their case in immigration court. Because of this, the process is often more complex than many people expect and requires strong supporting evidence. To be considered for 42B, a person must first be a non-permanent resident and be in removal proceedings before an immigration judge. But these requirements alone are not enough. The law requires applicants to satisfy several additional conditions before a judge can approve this type of relief. Simply living in the United States for many years does not automatically make someone eligible. Every requirement must be supported with credible evidence and documentation. What are the main requirements? One of the most important requirements is proving continuous physical presence in the United States for at least 10 years before receiving the notice to appear that begins removal proceedings. Applicants must also demonstrate good moral character during that period. The immigration judge may review many aspects of a person's history, including criminal records, immigration violations, and other factors that could affect eligibility. Another key requirement is proving that removal would cause exceptional and extremely unusual hardship to a qualifying relative. In most cases, that qualifying relative must be a U.S. citizen or lawful permanent resident spouse, parent, or child. This is often the most difficult requirement to prove because the hardship must be much greater than the normal emotional or financial difficulties that most families experience during a deportation. The judge may consider medical conditions, educational needs, financial circumstances, or other significant hardships affecting the qualifying family member. Who makes the final decision? Even if someone appears to meet all the legal requirements, approval is never guaranteed. The final decision belongs to the immigration judge. The judge will carefully review all documents, hear testimony, evaluate the evidence, and determine whether the applicant qualifies under the law. The judge may also consider the credibility of the applicant and whether the evidence presented fully supports the request for relief. That is why every immigration case is unique. Two people with similar situations may receive different outcomes depending on the strength of the evidence presented and the specific facts of each case. Many people hear about 42B and immediately assume they qualify because they have lived in the United States for a long time. Unfortunately, that is not enough. This form of relief has strict legal requirements, and every element must be properly documented. Understanding the process and knowing what evidence may be needed can make a significant difference when presenting your case before an immigration judge. Preparing a strong case requires careful planning, supporting evidence, and a clear understanding of immigration law. Knowing your options before making important decisions can make a significant difference in your case. 42B may offer hope to certain individuals facing deportation, but it is not available to everyone. Eligibility depends on meeting specific legal requirements, presenting strong evidence, and convincing an immigration judge that the law supports your request. If you or a loved one is currently in removal proceedings and would like to know whether 42B may be an option, contact us today.